Hey, so I have completed a free will application online form to see what kind of document, because it's not a plan, what kind of document these things are preparing for you. And let me tell you, there's mistakes. So the first thing they tell you when you print it out is free will is not a law firm and does not provide legal advice. Clearly, these are not drafted by attorneys, but they ask you questions that are asking legal advice. So guess what? They are committed to the unlicensed practice of law. So let's continue. Okay, so big thing that I already see as a mistake, as executor power, they have a power to exercise all powers of an absolute owner of property. What the heck is that? That is not the kind of authority that you want to be giving an executive or an estate. Why? Because an executor is supposed to manage property on behalf of the beneficiaries of your estate. They are not supposed to be giving absolute power as an absolute owner of a property. They're not the recipients of your estate. They are not your designated heirs in essence. So that's one giant, big, scary mistake. Under digital assets section, right? We all own digital assets. If you have things on Facebook, if you have things on LinkedIn, anything that you've created, video, those are all digital assets, right? They make absolutely no reference to the digital asset statute in the state of Florida. So, yeah. As far as special gifts for pets, right? So I put in, I have a pet and I like to, they ask you how much money do you want to leave for your pet. But here in the clause it says, I give to my pet caregiver the sum of $10,000 and I request that this gift be used for the care of my pet. But that's not enforceable because you're actually leaving it for that person. In fact, it says, I request but do not direct. Well, guess what? That means they can take that $10,000 and run with it. Other things that are really big mistakes, especially if you're not dealing with an attorney, right? This tendency of these documents online to just direct that all of the estate or inheritance taxes be paid out of the residue of your estate. Well, guess what? With these cheap wills, everything's thrown in the residue, meaning all your assets are thrown in as the leftovers of your estate, so that everything, including your homestead, is affected by this language. Because in Florida, homestead protections are really tricky, and the way and the wording that's used, you got to be really, really careful to not lose the homestead protections, creditor protections, that would otherwise be available for your family members. So another big right? And the other thing that's not well done in these documents is that when they talk about the residue and payment of all expenses coming out of residue, yeah, guess what? They're including your retirement accounts, which retirement accounts work differently. There's income tax issues that are arising there, and guess what? You're now directing these income taxes be paid through the residue of your estate, really leaving very little behind for your family members. Okay, they have a spendthrift provision. Spendthrift provisions, when well done with an attorney that knows what they're doing, are designed to keep assets away from creditors of your beneficiaries. Well, the way this is written just says, hey, until things are distributed to them, no creditors can touch them. Great, but that's not really a spendthrift provision, not one that's actually going to make sense in protecting young people from the difficulties of coming into money, right? So a real conversation with an attorney that is specialized in estate planning is going to let you understand why that's not a very effective spendthrift provision. And then there are other issues, right? So this one purports to create a special needs trust or provisions for special needs. This is when somebody needs access to Medicare or Medicaid or something else because they have either a disability or something similar, right? But the language that they put in for a spendthrift trust is the wrong language to protect benefits. It's actually something that's known by specialized estate planning attorneys, but it's not known by entities that are not attorneys. And so here they'd have language that would in fact put the special needs beneficiary at risk because of how it describes what kind of things a beneficiary would receive from this. So the other thing that I was like, oh man, bad idea. They ask, do you want a self-proving affidavit, with very little explanation about what a self-proving affidavit is or why it's there. And in fact, that should never be a question. It should always be included. But anyway, I digress. So the cheap, even free wills you find online, they're not a plan. They're a set of mistakes that you don't understand.